Good day, we are from Group 3. We are present on the legal position of adoptions and domestic violence in Malaysia. I believe you have a rough idea on what is adoptions. It's a legal process to grant new parenthood to a child. It can also be done with a single parenthood. Do you know what is the difference in adoption between Muslim and non-Muslim? As for Muslim, adoption is allowed by way of kafala or guardianship, and whereas for non-Muslim, it's mainly allowed in accordance with the legal provisions. Basically, Adoption Act 1952 is only applicable to Peninsular Malaysians and non-Muslim. Pertaining to the requirements of the child under Section 4 of Adoption Act, it can be either male, female or divorced female, but it must be less than 21 years old and reside ordinarily in West Malaysia. Essentially, the adoption is only completed when the child has been living under continuous care and possession of the applicants for 3 consecutive months according to Subsection 4. Secondly, applicant is the person who proposed to adopt or who has adopted the child solely or jointly. They must attain the age of 25 and 21 years older than the child. Under Section 4, applicant must reside in West Malaysia and have the same gender as the adopted child. This means a husband cannot adopt a child on his own. Moving on, according to Section 5, the consent must be acquired from the child's natural parent or guardian. It will be taken into account the welfare and living of the children. To illustrate, in the Re-SS case, the father was a drug addict and jobless. The court granted adoption order regarding the illegitimate child to mother who remarried with another man. In regards to the jurisdictions, as per Section 3 and 10, the authorization for applications may be from High Court or Sessions Court. For the last thing, as for procedure, the applications should be attached with the required form and written consents.
Hi and Assalamualaikum. I am Inani Zulkifli, metric number 272221 will be presenting on adoption for Muslim. And as mentioned before by the previous presenter, adoption means a legal process to grant a new parenthood to a child, and adoption for Muslim is allowed by way of kafala. And by referring to the Registration Adoption Act 1952, which enable adoption to be made for Muslims since it has no contradiction with the Sharia, as laid down in the provision, the requirement for the child in order to be adopted fall under Section 6, subsection 1, where the child must be under 18 and unmarried in order to be adopted. Second, the child must ordinarily be resident in Peninsular Malaysia. And the third, the child is not the subject of adoption order under Adoption Act. Moving on to the requirement for the applicant, where Section 10, subsection 2 stated that the applicant must be 21 years or older and at least 21 years older than the intended child. And subsection B mentioned that the applicant also can be 21 years or older and is a relative of the child either by consanguinity or affiliation, and the applicant also can be the child's natural parent. Moreover, we have Section 10, subsection 3, where one or both adoptive parents must ordinarily be resident in Peninsular Malaysia. And if one decided to adopt a child, consent need to be obtained by virtue of Section 6, subsection 1, subsection B, where the applicant must acquire the child's birth parents or guardian consent. And for the jurisdiction and procedural part will further be explained by next presenter. That's all from me. Thank you.
Assalamualaikum and hi, my name is Nasrin Binti Zuperi and my metric number is 272244. So I will be presenting on the jurisdiction and procedural matters regarding registrations of adoptions for Muslims. First, as you can see in the slides, it was mentioned under Section 3 of Registrations of Adoptions Act or RAA that applications are to be made to the Registrar General. For Section 7 of RAA, it was also mentioned that the registrar would require the adoptive parents to provide all relevant documents to be sent to the Registrar General. Well, lastly, under Section 8 of RAA, it was mentioned that the registrar would interview the adoptive parents and witnesses to testify. In this part, it is important to be noted that all persons involved in the sessions need to state the truth and to answer truthfully all the questions given by the registrar. In conclusion, it can be said that the RAA is silent on the legal effects, but in accordance to Islam, the adoptive parents must be responsible to the well-being and living of the child. However, the child cannot inherit from them. So I'll pass the floor to the next presenter. Thank you.
Good days to madams and my friends. My name is Lim Jun Ni, metric number 272913. I'll be presenting on domestic violence. Under United Nations context, domestic violence is defined as pattern of behavior in any relationship that is used in control an intimate partner. Four governing statutes for these issues are Domestic Violence Act, Law Reform Act, Penal Code, and Child Act. Married Women Act may also be applicable here. Domestic Violence Act specifies 6 types of acts which occur in domestic violence, namely physical injury, sexual abuse, misappropriation of property, threats, emotional or psychological abuse, and confinement. The victim covered under the domestic violence includes the spouse, the former spouse, child, incapacitated child, and other family members of the victim. To protect these victims from domestic violence, the Act provides 3 types of protection order, namely emergency protection order provided under Section 3A, interim protection order under Section 4, and protection order under Section 5. Each of them have different validity period. The court may also grant extra order for the victim under Section 6, subsection 1 to provide necessary protection for the personal safety of the complainant. This can be seen in the case of Jennifer Patrica, where the wife sought for an exclusion order to restrain the abusive act of her husband against her and her children. If the abuser violates the protection order, punishment under Section 8 will be adopted, with maximum imprisonment term not exceeding 2 years or maximum fines not exceeding 5,000 ringgit. The offense is separated into 3 categories. First, willful contravention. Second, willful contravention by using violence on a protected person. And third, subsequent violation of the protection order. The punishment will be differ according to the categories. Section 3 of the Domestic Violence Act provides that the provision in Penal Code must be read together with this Act so that the victim can take legal action against the abuser. Next, I will pass the floor to Nina. Thank you.
Assalamu alaikum, Doctor and my fellow friends. I'm Ilieyeennur Binti Ibrahim, metric number 272732, and I will be continuing the presentation on domestic violence. First of all, the position of domestic violence under LRA is not expressly stated. However, a woman can, in respect to Section 53, subsection 2 of the LRA, petition for divorce where the marriage has irretrievably broken down. The woman cannot be expected to live with the respondent as a result of domestic violence. In addition to that, in accordance with Section 50 of the LRA, the grounds of divorce due to domestic violence should allow for the petition of divorce within 2 years of marriage due to the exceptional circumstances. Lastly, in accordance with Section 103 of the LRA, it provides the ability of the court to issue an injunction order against molestation during the pending of divorce, judicial separation, or annulment order. Moving on to our next point. In respect of instant protection available to the victim, the first protection is medical assistance, including medical evidence that can be collected at one-stop crisis center provided in government hospitals while making a police report. The second protection is the protection order assistance, where the officer from the social welfare department will accompany the victim to get an interim protection order from the court. Moving on to our next point. A victim of domestic violence is also entitled to claim compensation for the personal injuries, damage of properties, or financial loss as a result of domestic violence in accordance with Section 10 of Domestic Violence Act. Continuing further, enhancing awareness to the community is a must, as the reported domestic violence statistics shows that 2,287 cases have been reported over the period of MCO in 2020. Referring to these statistics, there is no doubt that there must be actions taken to curb domestic violence. In conclusion, we cannot deny the existence of domestic violence as it is indeed a damaging issue. Victims of the act should contact the appropriate authorities for help, and the victims should also be aware of the appropriate steps they must take. These steps are necessary to ensure the safety of the victim in cases of domestic violence. So being aware of domestic violence is clearly important. That is all for our group presentation. Thank you, Doctor, and my fellow friends, for your attentiveness during our presentation.